the last subsection of the rules, we'll be discussing judicial conduct. Judicial conduct makes up 2 to 8% of your total MPRE examination. So one thing I want to point out before we dive into a few rules. A lot of people have asked me in the past when they're preparing for the MPRE if this is a section of the rules that they could skip because it's so infrequently tested. And my answer is, of course, no. All of these rules are fair game, and even though these rules, specifically the rules regarding judicial conduct, are not super heavily tested, they're still tested. And you might as well put yourself in the best position possible to get as many points as you can. So knowing that, I would never tell you to ignore any specific area of these rules. Now, understanding the frequency in which these subtopics are tested is very helpful in allowing you to use your time efficiently and effectively. So would this be the first subsection that I would tell you to devote a ton of time and attention to? No. Conflicts of interest is the most highly tested topic. But you still want to study this, just keep it in the correct context. So the first rule in this subsection that I want to talk about is all about the judge performing his or her duties in their judicial office impartially, competently, and diligently. If you remember back to a few videos ago, I gave you this description of regular lawyers, prosecutors, and judges. And I told you that the framework I provided was how I like to think of lawyers and their ethical responsibilities with respect to one another. And I'm going to remind you about that here because I think it makes a lot of sense as we think about this rule. So I said that us normal lawyers are kind of down here on a lower rung of the ladder. Then it's those prosecutors and governmental lawyers that are kind of the next rung up. And by that I mean they have an increased ethical obligation than normal lawyers have with regard to certain things. Then above those prosecutors and governmental lawyers are judges. They have an, again, even more increased ethical obligation than us regular lawyers and even us governmental lawyers or prosecutors. So keeping that in mind, let's talk about disability and impairment. So the rule says that a judge having a reasonable belief that the performance of a lawyer or another judge is impaired by drugs or alcohol or by a mental, emotional, or physical condition shall take appropriate action, which may include confidential referral to a lawyer or judicial assistance program. It may also include directly speaking to the person. So this is what I mean by that extra ethical obligation we're placing on these guys. Here, the judge needs to take action. The rule specifically says they shall take action if they have a reasonable belief that a lawyer or a judge's performance is being hindered in some way. But whatever that action is could differ depending on the circumstances presented. It could be just talking to the person and kind of leveling with them to see what's going on, or it could be going as far as referring them to some sort of substance abuse program. The next rule is all about responding to judicial and lawyer misconduct. So I'm hoping that this first rule looks very familiar to you because it's one that we've already covered, but it's so important, I thought it was worth discussing briefly again. So this rule says that a judge having knowledge that another judge or lawyer has committed a violation of these rules, so the judicial rules regarding conduct, as well as the model rules of professional conduct, that raises a substantial question regarding that judge's or lawyer's honesty, trustworthiness, or fitness as a judge or lawyer in other respects, shall inform the appropriate authority. So this is identical to that reporting rule we talked about for regular lawyers. So the same rule applies to judges. They have this obligation to report professional misconduct regarding lawyers and judges that they see. So remember that two-part test that I told you about. First, double check that the fact pattern gives you knowledge, because this rule requires knowledge. There is no duty to report misconduct if you don't know that it occurred. Assuming the fact pattern communicates that the lawyer or judge in question has knowledge, the next thing to ask yourself is what type of rule violation is at issue. Remember, not all rule violations have to be reported. If that were the case, the rule would simply state that. Instead, the only types of rule violations that must be reported are those that raise that substantial question to the lawyer's honesty, trustworthiness, or fitness in other respects. But remember what I said about us placing this extra or heightened kind of responsibility upon judges. And that's because the rules continue with this regard. They say, a judge who receives information indicating a substantial likelihood that a judge or a lawyer has committed a violation of these rules shall take appropriate action. This could be talking to that judge or that lawyer about it or reporting them to proper authorities. So here, not only is there this responsibility for a judge to report rule violations that they have knowledge of, that raise those substantial questions to the judges or lawyers' honesty, trustworthiness, or fitness. But there's this additional requirement that says if a judge comes to know about information that indicates a substantial likelihood that another judge or lawyer has committed a rule violation, they need to take appropriate action. And again, that appropriate action could differ depending upon the circumstances. So I want to give you a quick example about something that I've seen before. Let's say a judge is walking through the hallways of the courthouse one day, and the judge overhears two lawyers talking about another lawyer that this judge happens to know. And this person is identified by name. And these two lawyers are talking about how this specific lawyer in question has been showing up quite frequently drunk and falling asleep and unable to do his job and smelling like alcohol. And everyone is kind of concerned and looking sideways at this lawyer, but no one has stepped up and said anything. So in this instance, is this a situation where the judge would have an ethical responsibility to do something? And I would say yes. I think overhearing this information, hearing this lawyer identified by name, it's someone that this judge frequently sees. This information being reported is very specific about specific instances in which this lawyer appears to be drunk at work. This is enough to raise that substantial likelihood that there might be rule violations occurring and the judge needs to take appropriate action. So again, the judge might just have a face-to-face private conversation with this person. And that might be what is appropriate under the circumstances. But nonetheless, there is this requirement on the judge to act. And then the final rule in this vein that I want to cover is all about cooperation with disciplinary authorities. So the rule says that a judge shall cooperate and be candid and honest with judicial and lawyer disciplinary agencies. A judge shall not retaliate directly or indirectly against a person known or suspected to have assisted or cooperated with an investigation of a judge or a lawyer. Remember, we are a self-reporting profession. We have to tell on ourselves and each other, essentially, right? So here, our job with respect to these reporting requirements is therefore to cooperate with an investigation that might result. Here, a judge has that obligation. They can't take steps to hold an investigation against someone, or if they find out that someone helped aid in an investigation, they can't hold that against the person that helped. The judge just has to be essentially neutral here and understand that this is part of their job. The next rule that I want to talk about is disqualification. I feel like such a large number of these judicial conduct questions we get is on disqualification. So I want to make sure that it's clear. So the general rule says that a judge shall disqualify himself or herself in any proceeding in which the judge's impartiality might reasonably be questioned, including but not limited to the following circumstances. So I want to stop there before we dive into these enumerated circumstances. This is saying that the list we're about to cover is not exhaustive. They're just circumstances in which we know a judge's impartiality is questioned. Look at the plain language of the rule. It says a judge shall disqualify themselves in any proceeding in which their impartiality might be questioned, included but not limited to the following. So in other words, there are plenty of circumstances that are not captured by this list. So if you get a fact pattern that illustrates how a judge's impartiality may be questioned under the facts, it's definitely a situation where disqualification is at issue. So let's look at some of these scenarios where disqualification is appropriate. If the judge has personal bias or prejudice concerning a party or a party's lawyer, or has personal knowledge of facts that are in dispute in the proceeding. If the judge knows that the judge, their spouse, or their domestic partner or person within a third degree of relationship to them, or their spouse, or their domestic partner is a party in the proceeding, or some sort of officer, director, general partner, trustee, or managing member of a party, or if they're acting as a lawyer in the proceeding, or a person who has more than a de minimis interest that could be substantially affected by that proceeding or is likely to be a material interest witness in that proceeding. So to stop there, Basically, this is a situation where it's not just enough that maybe the judge is, a witness, because obviously that's very problematic. They would have to disqualify themselves. But if anyone that the judge could be affected by, like their partner or their spouse, for instance, has an interest in a proceeding, or is a lawyer in the proceeding, or is that party to a proceeding, or a witness in that proceeding. Those are all situations where the judge's impartiality would be questioned, and the judge needs to disqualify himself or herself from the action. The next portion of the rule says when the judge knows that he or she individually or as a fiduciary or the judge's spouse, domestic partner, parent, child, or any other member of the judge's family residing in the judge's household has an economic interest in the subject matter, in that controversy, or in the proceeding. So again, this is expansive. It's not just the judge who might have an economic interest that would lead to disqualification. It's anyone in the judge's house. If they have an economic interest, it's definitely grounds where the judge would be deemed impartial and needs to disqualify himself or herself. The next set of circumstances states that when the judge knows or learns by means of a timely motion that a party's lawyer, or a law firm of a party's lawyer has within the previous years made a certain number of contributions to the judge's campaign. So this is a scenario where the judge just might know who his or her main contributors are, or people who have contributed a lot in the past. And if that's an instance that comes in front of the judge, or those people come in front of the judge, that's absolutely a time in which their impartiality would be questioned and they should disqualify themselves. But it's also a situation where maybe if they don't know and this is raised on motion, the judge needs to be aware of that, take steps to then disqualify himself or herself. The rule goes on to say that if the judge, while serving as a judge or judicial candidate, has made a public statement other than in a court proceeding, judicial decision, or opinion that commits or appears to commit the judge to a particular result or to rule in a particular way in the proceeding or controversy. So if the judge has made a particular statement that basically promises to do something and then the case gets in front of him or her, they need to disqualify themselves because they are going to look very impartial. Their impartiality would be questioned. Similarly, if the judge did any of the following, they need to disqualify themselves. If they served as a lawyer in the matter or in the controversy, or if they were in fact associated with a lawyer who participated substantially as a lawyer in the matter during the association. So to stop there, if the judge worked at a big law firm before taking the bench and one of the lawyers at his firm was working on a case, even if he didn't personally work on it himself as the judge, but someone he worked with did, we just assume the judge might have information that would be problematic. So if this case comes in front of the judge, he needs to disqualify himself. Or if the judge served in governmental employment and in such a capacity participated personally and substantially as a lawyer or public official concerning the proceeding, or has publicly expressed in such a capacity an opinion concerning the merits of the particular matter in the controversy. So in this instance, it's kind of the exact same thing I said in the private sector but now just government. So if in any way in their previous job, if they worked for the government prior to taking the bench, if they had been involved in the matter, they need to make sure that they're disqualifying themselves if this matter comes in front of them. Or if the judge is a material witness in the matter or previously presided as the judge over the matter in another court, they need to disqualify themselves. So remember, this list is not exhaustive, but instead it's just some circumstances in which we know the judge's impartiality would be questioned and therefore disqualification would follow. But it is not the only instances of disqualification. So on that note, judges have this obligation to keep informed about their own personal and their fiduciary economic interests, and they have to take reasonable steps and make a reasonable effort to keep abreast and informed of this information, not only about their own personal interests, but as well as the interests of the people in their household, like their kids or their spouse or their domestic partner. So this is placing an obligation on them to basically stay informed. It's not enough for a judge just to say, I didn't know, because a judge should know, because they should be staying informed. So turning to this idea of disclosure, a judge must disclose on the record information that the judge believes the parties or their lawyers might reasonably consider relevant to a possible motion for disqualification. even if the judge believes there isn't a basis for disqualification. So if the judge thinks that there is any reason someone might think he or she can't handle the case or shouldn't hear the case, the judge needs to put that information on the record and let the parties decide how they feel. Even if the judge believes that they can do their job and that they can be impartial, that's okay. But if there's still information out there that the judge has, and maybe if he were in the lawyer's shoes or in the party's shoes, he'd want to know, then that's the type of thing he should put on the record. Now let's talk about waiver. Judges subject to disqualification under this rule, other than for reasons like bias or prejudice, are allowed to disclose on the record the basis for their disqualification and then ask the parties to consider, outside of the presence of the judge and outside of the presence of the court personnel, whether they would waive the disqualification. And if following this disclosure, the parties and lawyers agree, without the judge or the court personnel participating, that the judge shouldn't be disqualified, then the judge can move forward and participate in the proceeding. And the agreement reached needs to be incorporated on the record. So I just want to stop there. This is a situation where the judge puts on the record basis for disqualification, but basically tells the parties, this is information you need to know that technically could disqualify me, but I don't think I should be disqualified. Please don't disqualify me. Basically what he's asking is for them to recess, leave court, discuss amongst themselves in private what they think and feel about that information, and then to come back together on the record and to make a decision. So the parties might want to disqualify the judge. They might be concerned, and they have every right to make that decision. Or they might come back and say, yeah, we're really not concerned. We want to move forward. And then that gets put on the record, and then the judge can move forward and hear that case. So please remember that the judge has to let the parties decide this outside of the court's presence. It's not something that the judge can put them on the spot and force them to decide on the spot. If so, that would violate this rule. So I want to give you one quick example of waiver before we move on. Let's say a judge is hearing a case between a plaintiff and a defendant. The plaintiff happens to be his second cousin, and the defendant is being represented by a lawyer that is currently married to the judge's college ex-girlfriend. And the judge is kind of miffed that this defense attorney is married to his ex-college sweetheart. He always thought that his ex-girlfriend should have married him instead of this defense attorney. The judge decided, however, even though he's biased and prejudiced against this guy, he's going to be open-minded and hear the case anyways. He puts on the record information about his relationship with the plaintiff and asks the parties to waive his disqualification. And he allows the parties to obviously converse in private, out of the courtroom and out of the presence of the judge and the personnel, basically to waive the reasons for disqualification. Ultimately, the question I pose to you is what the judge did ethical? Or did the judge violate these rules? And the answer is, under these facts, the judge cannot ask for waiver of disqualification because I told you that he specifically feels biased and slightly prejudicial towards the defense attorney. And remember, you cannot ask for a waiver if you think you are biased or prejudiced. The rule specifically says you can ask for a waiver of disqualification for everything basically other than bias and prejudice. The next part of this rule says that a judge's obligation to not hear or decide a matter in which disqualification is required applies regardless of whether or not a motion for disqualification is filed. So this essentially means that a judge shall not wait for a party to file a motion for disqualification to basically bring this information that's relevant in front of the parties. If a judge knows that this information exists, he needs to put these reasons for disqualification on the record, even if they haven't filed a motion. This is the judge's responsibility. Getting to the next issue of necessity. So the rule of necessity may override a rule of disqualification, and I want to explain what this means. So if there's ever an instance in your fact pattern where there's not another judge available, and there's a very time-sensitive matter, then even if the judge is otherwise supposed to be disqualified, we would allow this necessity to overrule or override that issue of disqualification, so that otherwise ordinarily disqualified judge could make that very time-sensitive decision since no one else is available. But that's it. Then the judge would have to hand it off to someone else who's better equipped and better qualified to handle the case. So just know that sometimes the rule of necessity might have to override disqualification. But usually, again, those reasons are because it's time sensitive and no one else can handle it based upon the sensitivity of time in which it's presented. So the next rule that I want to discuss is extrajudicial activities. So generally speaking, judges are allowed to engage in extrajudicial activities, but when they do engage in these activities, they can't do certain things. So let's talk about these things in which they can't do. The first is they're not allowed to participate in activities that will interfere with the proper performance of their judicial duties. So stopping here, this means first things first, a judge is a judge is a judge. This is their first and their main job. So they need to make sure they're capable and able to do that before they start engaging in other activities. If these other activities are getting in the way of a judge being able to do their job, then they can't do those extra activities. Next, participate in activities that will lead to frequent disqualification of the judge. And as I just mentioned, being a judge comes first. So if engaging in certain activities causes the judge to have to disqualify themselves frequently, that means they can't do their job. And if they can't do their job, that's problematic. So they shouldn't be engaging in those extrajudicial activities. Next, participating in activities that would appear to a reasonable person to undermine the judge's independence, integrity, or impartiality. So if you see a fact pattern that a judge is participating in a group that maybe has discriminatory practices, for instance, the judge is not supposed to have any association with that group, because then we'll associate the judge with them, and those people clearly discriminate or have their own issues that would call into question that judge's independence, integrity, and impartiality. Judges engaging in conduct that would appear to a reasonable person to be coercive cannot do that. So while they can engage in these extrajudicial activities, they need to be sure that they're not appearing coercive. And then making use of court premises, staff, stationary equipment, or other resources, except for incidental use of activities that concern the law, the legal system, or the administration of justice, or unless they're otherwise permitted by law. So this essentially just says, while they're allowed to participate in extrajudicial activities, they shouldn't be using court resources to do so unless it's an incidental use for something that's specific to the law, the legal system, or the administration of justice. The next rule that I want to discuss is participation in things like educational, religious, charitable, fraternal, or civic organizations and activities. So here the rule says that judges can participate in activities sponsored by organizations or governmental entities concerned with things like the law, the legal system, or the administration of justice. And those sponsored by educational, religious, charitable, fraternal, or civic organizations that are conducted for profit, including but not limited to the following activities. So again, just to stop here, this is another reminder that these are all of these things that a judge can do, but it's not exhaustive, okay? So just because something's not on here doesn't mean they can't necessarily do it. So they're allowed to assist the organization or entity in planning related to fundraising, so they can help them make plans to raise funds. They can solicit contributions for these organizations or entities, but only from certain people, specifically members of their family or from other judges over which they do not have a supervisory or appellate authority over. Remember, judges can't be seen to be acting coercive, and we don't want them pressuring people into maybe giving them money. So we want to make sure that anyone that they are soliciting funds from are normal people in the judge's everyday life that they really don't have any sort of special power over. They're allowed to solicit membership for these organizations or entities, but only if this organization or entity is concerning the law, the legal system, or the administration of justice. So you'll notice a theme here. These entities that are concerned with the law, the legal system, or the administration of justice are given basically preferential treatment under these rules. Appearing at or speaking at, receiving an award or another type of recognition, or being featured in the program of, and permitting their title to be used in connection with an event of an organization or entity. But if this event is serving some sort of fundraising purpose, then the judge can participate only if those events concern the law, the legal system, or the administration of justice. So stopping there, you can see that law, legal system, or administration of justice pop up again. So judges are allowed to participate in these events and speak at or get an award at or have their title used in these fundraising events, but only if it's an event concerning the law, the legal system, or the administration of justice. If they're participating in a different organization event that does have a fundraising purpose, then they can't do those things like speak, appear, receive an award, use their title, and the like. We generally do not want the judge fundraising. Making recommendations to such a public or private fund granting organization or entity in connection with its programs and activities, but only if that organization is concerned with the law, the legal system, or the administration of justice. Serving as an officer or a director, trustee, or non-legal advisor of such an organization or entity, unless that organization or entity will be engaged in proceedings that would ordinarily come before the judge or will frequently appear in the courtroom which the judge sits or is under their appellate jurisdiction. Because this would lead to a situation where they would have to frequently, disqualify themselves. And remember, a judge's obligation is first to be a judge. They're not supposed to be doing things off the bench that impedes their ability to do their job. So if participating in this manner would lead to frequent disqualification, then they're not able to do it. The next thing I want to discuss is compensation with respect to these extrajudicial activities. So the general rule is that a judge may accept reasonable compensation for extrajudicial activities permitted by these rules or other law, unless such acceptance would appear to a reasonable person to undermine the judge's independence, integrity, or impartiality. So stopping there, you'll notice that this rule does not provide us with like a hard and fast dollar amount that's applicable here. So it's not like you can just look for a dollar amount in your fact pattern. Instead, they're just saying that the judge should never accept anything that would call into question their independence, integrity, or impartiality. So just keep that in mind. There's not this hard and fast dollar amount that you must memorize. The next rule that I want to discuss is kind of in that vein. It's about reimbursement of expenses and waivers or fees or charges. So here the rule says, unless otherwise prohibited by these rules or another law, a judge may accept reimbursement of necessary and reasonable expenses for travel, food, lodging, or other incidental expenses, or a waiver or a partial waiver of fees or charges for things like registration, tuition, and the like, from sources other than the judge's employing entity, if those expenses or charges are associated with the judge's participation in extrajudicial activities permitted by these rules. So stopping there, assuming that the judge is participating in something they're allowed to participate in ethically, then they too can receive waivers for fees or partial waivers for fees or reimbursement for expenses that they've incurred as a result of their participation. So to be clear, if they can't participate by virtue of the rules, then they also can't accept reimbursement or a waiver of fees with respect to that activity. Now, the next part of this rule, though, goes on to tell us that reimbursement of expenses for things like that necessary travel or food, lodging, or those other incidental expenses need to be limited to the actual costs reasonably incurred by the judge and, when appropriate and on occasion, to the judge's spouse, domestic partner, or guest. So stopping there, this means if the judge is being reimbursed for their own flight or lodging or food, and they've been allowed to bring their husband or a guest, and this group wants to reimburse the judge for the guest fees, she can accept or he can accept reimbursement for their spouse or guest as well. Now, a judge must assure himself or herself that acceptance of these reimbursement of fees or waivers would not appear to a reasonable person to undermine the judge's independence, integrity, or impartiality. And there are some factors that a judge can consider when deciding whether or not to accept reimbursement of fees or a waiver of fees for attending a particular activity. So to stop there, again, there's not a fast and hard dollar amount that you must memorize here. It's not like there's a certain threshold in which the judge can or cannot accept. Instead, the judge needs to make the assessment of whether or not accepting this type of reimbursement or waiver would call into question by a reasonable person their independence, integrity, or impartiality. And remember that this is a list of factors, meaning none of these are necessarily dispositive, I would say. And similarly, this is not exhaustive. These are just things that the judge should consider when making this decision. So I'm not going to read all of these, but just a few of them that I think stand out. The first is whether the sponsor is an accredited educational institution or a bar association rather than a trade organization or a for-profit entity. Whether the funding comes largely from numerous contributors rather than from a single entity and is earmarked for programs with specific content. Whether the activity is primarily educational rather than recreational, and whether the costs of the event are reasonable and comparable to those associated with similar events sponsored by the judiciary, bar associations, or similar groups, and whether information concerning the activity and its fundings are available upon inquiry. Lastly, keep in mind that when a judge accepts reimbursement of expenses or waivers, or a partial waiver of fees on behalf of themselves or their spouse or their domestic partner, has to publicly report these types of things pursuant to these rules. And there are reporting requirements in rules, so this is just a nice reminder that acceptance of these things would trigger the reporting requirement. So that wraps up our discussion of the rules regarding judicial conduct.